And we are live. Welcome to Crypto Law TV. I'm John Deaton, the founder and your host. I haven't done one of these in a while, and I got to tell you, I'm a little charged up. I am on my third cup of coffee. And on top of that, I'm looking at this thing. I know many of you feel the same way. The case that never fucking goes away. And going through this little brief in the Ripple SEC case, it was only like 3.5, 4 pages. As I was reading it, it brought back damn issues. You know, I remember fighting with Ripple lawyers. Maybe I'll share a little bit about that with you. But anyways, the case that never goes away. And let me preface what I'm about to say. I'm not an experienced securities lawyer in the sense that I've been doing this for 20 years. I remember when I filed the motion to intervene, career security lawyers were like, what this guy doing? He's an asbestos lawyer. What's he doing? This judge is never going to grant a motion to intervene of tens of thousands of people and make them defendants. And I'm listening to these comments and I'm like, no shit, Sherlock. Of course she's not going to say yes. SEC, now you have to sue tens of thousands of people. But I guaranteed it was going to get her notice. I guaranteed it was going to get her attention. And I believed it would guarantee that she would name me as amicus counsel on behalf of the public interest of 75,000 people from 143 countries around the world coming together saying we want our voice heard. We don't want the SEC to speak for us. We don't want Ripple to speak for us. Hell, half of us didn't even know Ripple existed when we bought XRP. So, granted, these attorneys, including the ones for Ripple, one of them, the guy that signed this brief, Andrew Resnick, great lawyer, never met him personally, certainly experienced. He was the director of enforcement. So they forgot about securities laws more than I'll ever know, okay? They could cite Second Circuit case law off the top of their dome faster than AI. I get it, all right? So, but sometimes new eyes are appropriate and are better. You know, I'll give you one example. I got those 4,000 affidavits for XRP holders, and I submitted them, right? And I had a meeting with Ripple lawyers who are great lawyers, good people, who I like them. And they're like, well, you know, but there's like 20 of them. And they're like, John, you know, love the effort that you did with the affidavits, but, you know, we're not sure we're going to use the XRP holder affidavits. And I'll tell you exactly what I said on the phone. What the fuck do you mean that you're not going to use the XRP holder affidavits? And this is how lawyers operate sometimes. John, how could we vet 4,000 people that sign these affidavits in case there's a trial? And you got all these 4,000 people, these affidavits. We can't vet those 4,000 people. To which my response was, why the fuck would you want to vet 4,000 people? Well, what if they're illicit purposes and they're bad people that, you know, I go, who cares if they're crackheads? In fact, you want some of them to be crackheads. It's called decentralization. Ripple doesn't control the XRP ledger. They can get, a crackhead can get on the XRP ledger and send money across border. And bad people can get on it. It's called an open, permissionless, distributed ledger technology. Ripple doesn't control it. Don't you see? That's actually helpful to the case. So use the goddamn affidavits. All right, that's a real story, and you know they know more than me. But guess what? The judge cited the affidavits. Okay, so you know some people, and to this day, I still haven't met a lawyer worth $2,500 an hour. I'm not worth it, and none of you lawyers that are watching this, if you do watch it, who think you're worth $2,500 an hour, you're not. Now let's talk about. I told you I was riled up this morning. Now. I told you that this brought up some kind of issues with me anyways. So let's talk about what's going on. And this is, remember, there's a settlement, a proposed settlement by the SEC and Ripple, where the SEC wants the judge to dissolve her injunction against Ripple and reduce the $125 million fine to $50 million. And if the Judge Torres is acceptable to that, agreeable to that, she will, by order, reduce the fine and dissolve the injunction, then this case goes away and there's a settlement. And And they thought she would probably rubber stamp it, right? It's just one other big case off her desk, and the judge Torres threw a curveball. So first of all, you cited the wrong rule. Second of all, you haven't demonstrated to the court that there are exceptional circumstances for me, Judge Torres, who followed the law and issued an injunction, for me to just say, I changed my mind, I'm going to dissolve the injunction. You got to do some effort. You got to show me some stuff, right? You got to meet this high standard. It's actually a high standard of exceptional circumstances. And so she said, come back to me. So I thought, well, shit, right? She's pissed off. For one, look at all the time that she spent on this case, 4.5 years, the amount of hours and resources and money and effort that was expended on this case. And all of a sudden the SEC says, psych, we changed our mind, Judge. We wanted $1.3 billion in a fine. And now we want you to take your $125 million fine and reduce it by 60%. She wants a little bit more. So I thought that the SEC and Ripple would put together a brief that'd be a little bit more than what they did. Now, I'm gonna, at the end of this, I'll tell you, I think she'll grant it like by 70%, but I'm gonna give you a little synopsis of why I think there should have been a better effort from this non-career securities lawyer's attorney who has way less experience than all of these experts, okay? But so first, let's understand what's happening. Ripple has an appeal and the SEC has an appeal. SEC's dropped their appeal. Ripple says they'll drop their appeal to the Second Circuit if you dissolve the injunction and we get back $75 million. I already told you Torres denied it. Now, settlement, exceptional circumstances. Know this. Under the case law, a settlement agreement itself is not enough to meet exceptional circumstances. And I'm going through the brief right now. The judge must basically judge the private interest served by settlement with the public interest of consistency of law, deterrence, what her fine means, what her injunction means. And the Second Circuit many times says exceptional circumstances exist where modifying the final judgment is necessary for the facilitation of settlement that would end the appeals. So understand this. There's enough case law cited in the SEC Ripple brief that allows the judge to give her something to hang her hat on, right? The Second Circuit says, yes, if dissolving the injunction or modifying the final order by the district court, if that's going to facilitate a settlement and drop everything so we can move on to other cases that are pending and save all that money and resources, then go ahead. You can do that. So there is enough there. Now, they also cite several cases. One case that says save judicial resources, a settlement, everything I just talked about. The plaintiff, the SEC has changed their aggressive litigation strategy against crypto. They explain all that. They explain that no non-parties, that's you and me and everybody else other than Ripple and the SEC, are going to be negatively impacted by her dissolving the injunction. They also cite a case where the government changed its litigation policy because of the presidential election. Now, don't think that meant American presidential election. It was an Argentina presidential election where the policy did a 180. But there is a case that they cite that says a presidential election, even if it's a foreign government, can change policy. All right. And so they then go on to say, look, Judge, this is a reasonable compromise between the parties to bring an end to avoid the litigation on appeal. So the SEC saying and Ripple saying to Judge Torres, look, Ripple could win. They could flat out win. Your injunction gets reversed and they don't have to pay any money. And we don't want that, Judge, because that could affect the SEC. So there's a risk, and there's a risk to Ripple that her judgment completely gets affirmed. And that's a worse deal for Ripple. So they're getting a benefit of the bargain here. The SEC's getting certainty, Ripple's getting certainty, and they say to the judge, that should be enough. They cite policy that favors settlements. The SEC can rely on her ruling and its presidential value because the injunction is case specific. It's not an injunction against all crypto companies. It's an injunction against Ripple for further violation of the securities laws of the United States. And so it's just Ripple, case specific. It's okay. Well, your ruling isn't reversing your actual ruling. For example, XRP itself is not a security. That doesn't get impacted. That's the law of the land as far as your ruling goes, Judge. And people can still cite your decision because it's a one of first impression related to crypto. So there's no reason that all your work wasn't done, without benefit. That's really what they're saying. And they're saying that this is just between these two parties. And they talk about the public interest, which I think they blew. The public interest, they're saying, look, Judge, the public interest in your fine and your injunction is low. I think that they did a bad job, quite frankly, on that argument, because her injunction is, Ripple, you're not allowed to violate securities laws, basically, going forward. And for them to say, well, that's a weak public policy argument, it's not. You know that I don't agree with the decision necessarily, and you all know that I'm pro crypto and all that stuff. But a judge saying to a company, and there are other companies in the industry, crypto companies, that you're not allowed to violate the law, and it acts as a deterrent. 175 million penalty, stiff. It's not 1.3 billion, but it's stiff. I want that out there. I want crypto companies to know that they need to beware. There's a strong public interest in that. You can make that argument, okay? And so that's basically, they go on to say, look, also the SEC launched a task force on crypto. And this case, if you dissolve this injunction and reduce the fine, it's consistent with other cases right now, Judge, because look, we dismissed Coinbase, Kraken, Consensus. They list a few cases. They missed a couple. They missed Dragon Chain, for example, but they cite a few of this 180 that the SEC's done. And therefore, her doing this dissolving the injunction and reducing the fine is consistent with all the other cases that are happening in America, which is a good argument to make. All right. So the SEC wants that dismissal. It ends the appeals, saves the resources of the Second Circuit and the resources of this court in case you remand this decision. And this is another area that I think they could have put more meat on the bone. Remember, Judge Torres didn't apply the entire Howey decision factors. She said that you did not prove that third factor, which has two prongs, right? That you relied on the efforts of others, blah, blah, blah. She didn't apply the second prong, common enterprise, for example. So the reality is, if the appeal goes up, the Second Circuit could say that we disagree with Judge Torres. You are now remanded the case. She reverses the decision on that prong, and now you have to apply the rest of the test. And then she'd have to go back and then apply all the facts, the common enterprise factor. That would take up a lot of her time. And so I think they could have, spilled that out a little bit more, but they didn't. And it's probably because they're taking a position, well, that is obvious, John. And they finally say it brings this litigation, this 4.5-year litigation, to an end. So therefore, you should do it, Judge. So what are we going to do? What is she going to do? Well, what I'm going to do now is give you a little argument of why she should not do it and why she should do it. And then you can decide. And then I'll give you my prediction. And again, I am obviously pro-crypto. Before I tell you this, before I give you a little synopsis of what could be made or what could be argued in the judge's chambers. The SEC's not arguing it, but her clerks and Judge Torres's brain, or maybe her and Judge Netburn get together and they brainstorm on what the judge should do. So I'm all in crypto, been fighting for it, but here's an argument that could be made. that, and also know that the bottom line is we have a high standard of exceptional circumstances. So the first argument is, look, this minimum thing that they submitted to the court does not meet the standard of exceptional circumstances. Okay, settlement alone is insufficient. It is not by itself an exceptional circumstance. So you can't grant it, Judge, just because there's a settlement. All right. The policy shift is not unique, Judge. This is what she could be thinking to herself, right? That Argentina case involved, something else in a foreign country. All that happened here, Judge, is the SEC got a new chair and we have a new president. You understand, Judge? Guess what, Judge? Judge Gary Gensler didn't like crypto. That's a fact, Judge. Gary Gensler thought that crypto was only for drug dealers and drug cartels and bad people, Judge. He said they all violate the securities laws except for Bitcoin, Judge. He wouldn't even admit Ethereum wasn't a security, Judge. That was Gary Gensler. Well, guess what? We got a new SEC chair named Paul Atkins. And guess what, Judge? He thinks crypto is the best thing since sliced bread or the best thing since New Coke. Now, I just dated myself because some of you out there may be old enough to know that Coca-Cola tried a new formula, New Coke, and it tastes like shit. And it was a disaster and they went back. Well, we got a new chair who wants to do things different. But you know what doesn't change, Judge? The law doesn't change. It doesn't matter who's in the White House when it comes to the law. And since those beautiful, delicious oranges were picked and harvested from the orange groves in Howie for 80 years, we've had the law. And the law doesn't change. Just because the president comes in and has a meme coin and the SEC rushes to say meme coins are collectibles, they're not violating securities laws, doesn't change the 80 years of law. Lady Justice is blindfolded. And you see the scales of justice equal. Why is she blindfolded? Because she doesn't give a shit who occupies the White House. Judge, and you know what the judge could be thinking? We just can't keep flip-flopping. What if, Judge, you dissolve this injunction and then there's a new election in 2029? And what if a new president comes in and puts in a Gary Gensler type? Are we just going to go back to everything in crypto's bad? Right? This flip-flopping back and forth, that's what separates the United States from all these banana republics. It's the law, Judge. And you spent years on this case and you made a decision, Judge. You followed the law and you gave an injunction. And that injunction says, Ripple, you're not allowed to violate securities laws moving forward. And all of a sudden, the SEC, because we got a new president, wants to come to this court and say, guess what, Judge? Elections have consequences. Well, the answer to that, Judge, is that elections do have consequences at our southern border on economic policy. Maybe people are going to get tax cuts instead of tax increases. But what doesn't change is the law. That's it, Judge. And you followed the law. And you know what, Judge? In this era of meme coins and going to the wild west here, think about Celsius, Judge, Voyager, BlockFi, FTX. Consumer protection is needed. And you decided that you were going to protect investors. While all this fraud and bankruptcies are happening all across crypto, you stood up to the plate, Judge, applied the law, and gave a ruling. And because we had an election, they just want you to come in and say, all right, we changed our mind. All right, you can't do that, Judge. You have to stand up to that. Be that blinded Lady Justice. Okay, those are the arguments that could be given. So that's why I thought there would be a little bit more in the brief. All right, because those arguments could be persuasive. Remember, you have a lifelong Democratic judge appointed by Barack Obama. I think Judge Torres has been a good judge. I'm hoping that politics and Trump derangement syndrome and all that's happening out there in the world objectively that happens. And I hope that her Trump meme coin and all that doesn't offend her and offend her thoughts of securities laws, and that she's going to allow that to impact her decision. So that's the point. Now, what was I expecting? What I was expecting was that there would be, look, Judge, all the things that they said, but then say, Your Honor, the SEC got it wrong. This new industry came along, and because of, we had a chair who implemented a super aggressive policy against crypto that was unreasonable. And there's plenty of things to cite that you could cite. Look, Judge, look what happened. Appellate court found our institution, the SEC, arbitrary and capricious, which is a very high standard when they denied the spot Bitcoin ETF. On top of that, Judge, we got so aggressive against crypto that we got sanctioned in a courtroom in the debt box case. Our lawyers got sanctioned because they went into court because they were so, on this aggressive crypto policy, they lied and perpetrated a fraud on the court. And even in the Ripple case, Judge, your magistrate that helped you on this case, Judge Netburn, wrote in a decision that the lawyers at the SEC lacked faithful allegiance to the law. That's how out of control the leadership at the SEC was. And we went too far, Judge. We went too far. We took this nascent industry that we didn't understand, and we just put our thumb on that scale of blind lady justice. That's what we did. And look what's happening today, Judge. You have a Genius Act that is going to come around and be passed. They're saying it's going to pass. And guess what? It involves stable coins. And you know what, Judge? This defendant, Ripple, they have one of those stable coins. And that's a reason we need to address this injunction. Because with all this clarity coming, why should Ripple be at a disadvantage with a dark cloud of an injunction over their head? That's not fair. It's not fair to Ripple when you compare everything that's happening. Also, there's a Clarity Act. Congress is acting, Judge, in a bipartisan way. And that is another factor that meets the exceptional circumstance standard, which is high. So it's not just because of a settlement, and not just because we want to eliminate the wasteful of judicial resources and save all that money and save all that time and effort, but there is another reason. Congress is acting because we shouldn't be applying a 1946 case law about oranges and orange groves to modern day artificial intelligence, modern day blockchain technology, quantum computing, automation, robotics. Finally, Congress is acting, Judge. We got it wrong. I thought there would just be some of that. Some people call it ass kissing, some people call it groveling. I just say giving her context, because you're asking the judge who believes, whether she's right or wrong, she believes that she belabored this decision. She went through thousands of exhibits and she applied the law. And now, just because things change, an election, new president, she should just dissolve that injunction. That's not, an easy thing. And she gave them a hint. She said, I'm denying it the first time. And it's not just because you cite the wrong rule, but you got to meet this high standard. And I just think the parties said, hey, there's some case law that supports this. We want a settlement. It's the right thing to do. Things have changed. And that she'll do it. And I'm not so sure that she's going to accept that. I mean, ultimately, I'll tell you what I think is going to happen, but that's something, that I was just a little bit surprised by. Let me see. Now, I saw that Freddie Riz had asked a question by what's so what? If there's an injunction, it's, no harm, no foul. If Ripple, here's the reality. Stablecoin legislation, it's not so much about XRP, but the stablecoin, with the stablecoin legislation being passed and us giving clarity, and you're talking about stablecoin market cap is going to be projected to be, by Scott Bessent, the Treasury Secretary, says 2 trillion market cap within the next couple of years. Brad Garlinghouse said that it's going to 5 or 10x over the next 5 to 10 years. Ripple is in the stablecoin business. And there are companies out there, the Banks of America, the Goldman, whoever, who just, it's better to not have this little dark cloud hanging. Yes, the SEC could give a letter that says we're not going to prosecute. What if the only thing that passes is the Genius Act? There is no Clarity Act. And what if there's a new election? And what if, because of everything happening, the Democrats win? Elizabeth Warren, they win the Senate. Elizabeth Warren becomes the chairwoman of the banking committee. You think crypto is bad again? Might be a theme. You think a new SEC chair after Paul Atkins, 3.5 years from now, could be a Gary Gensler-like? And then all of a sudden they could change. They could have an accident against them. So of course Ripple wants certainty, because there are some businesses out there to be like, well, listen, we'll just deal with Circle instead of Ripple, because Circle doesn't have an injunction against them. I thought there would be some of that in there. Like, this would be fundamentally fucking unfair, to be blunt. It would be unfair as we move forward with clarity in the markets for a participant like Ripple to have a little dark cloud over it, if you're going to be objective. And so I thought that there would be some discussion of that. So, what do I think she's going to do? I think that 70% chance that she's going to grant the relief is where I just randomly pick a percentage. It's much more than 50%. But listen, it's not an 80 or 90% thing, and you can see experienced securities lawyers saying that. We're asking this judge to basically, in many ways, ignore the law according to her, because they want the settlement to go forward. And, she could have a problem with that. Now, I've called Judge Torres a great judge, a good judge. She was fair. Doesn't mean I agree with everything. I did predict exactly how her ruling would come down, because I had a sense of her. I knew she cared about public interest. And with all of us, tens of thousands of people trying to get a voice in the courtroom, that she wouldn't be lost on that. I think the fact that she cited XRP holder affidavits proves that. But that's another thing. The SEC didn't even address that. They didn't even address that. Look, Judge, the public interest, if you're going to weigh the public interest, remember I just went over how they deminimized, the deterrence of an injunction and the deterrence of a big fine, and the public interest in keeping crypto companies like FTX, Celsius, BlockFi, Voyager, 3AC. Do I need to go on? To put them on notice, put the bad guys on notice that there will be consequences. All right. They minimized that public interest as far as I'm concerned, but they should have said, listen, look at our case, Judge. Look what happened. 75,000 people knocking on the door saying they want access to this asset class. America, over 1 in 4 adults in America now has exposure to this asset class. It is growing. Look at all the things that have happened and all the legislation, all the efforts. You got the president talking about making America crypto capital of the world. And in order to do that, we need this injunction. This is what the public wants. They want access to this asset class. There's no talk about any of that. Just here's some cases that give you enough to hang your hat on, Judge. And we want a settlement. So we want the settlement to go forward, and we think you should do it. But ultimately, I'm going to predict that she grants it. And the reason I predict that she grants it is because that there is enough case law there where it says, look, Ripple's not going to drop their appeal. So if you don't grant this, if you don't give us an indicative ruling that you will dissolve your injunction and reduce the fine to $50 million, Ripple won't drop their appeal. And that will tie up the Second Circuit in a big way. And there's Second Circuit case law that says that that's good enough reason, okay, with saving the resources and your court, Judge. If you get overturned on the secondary market sales, for example, it's coming back to you and tying this courtroom up in the massive resources. And who would want to do with that when you look at where the world and America is headed in this asset class? I think ultimately she's going to take that all into consideration, and that she's going to say, yes, let's move on and grant the issue. So anyways, I don't know if I covered everything. I have all these kind of notes around here to talk to you about, but I just wanted to give you a snapshot of what I thought. Not throwing the Ripple lawyers under the bus or anything like that. Just telling you that a guy who's a lawyer, experienced, who followed this case, was a part of this case, just thought there would be more meat on the bones. And these people are very experienced. They know the SEC. Maybe I'm wrong. Maybe I'm wrong, and that brief that they filed is all that needed to be filed because they're extremely confident that she's going to grant it. But I got to tell you, the last comment I'll make is I know there's someone who kind of might have similar thoughts as me, and that's Brad Garlinghouse. And the reason I say that, because he was on stage at XRP Vegas and he's like, hey, the lawyers are telling me that, it's no big deal. But you can still see from a non-lawyer layman's person, common sense kind of person, they're like, God, like this, I'm a little concerned, but I'm told not to be concerned. Well, I just would have done more because I think that getting a judge to change her mind after you went into court and banged on the table. You got to remember those sessions, all the massive litigation. Remember, the SEC was coming in saying $1.3 billion. They wrote a complaint that made Brad Garlinghouse and Chris Larson look like bad guys, even though it's a non-fraud case. The SEC was suing everyone in crypto, and she applied a rule, and now they wanted to change their mind. So I think she's going to do it. Don't get me wrong. Thank you for tuning in. If you did, to hear me rant this morning, I'm going to have a fourth cup of coffee, and then we'll go cut my damn grass. I hope you all have a great day. Keep up the faith. Love you. Peace out.